You guys were having some trouble. Yeah, I think we're live. Yeah, yes, we're live. Okay. So, hello and welcome everyone to another episode of the Agenda by the Indian Youth Economic Association. This week we are celebrating Shakti. This is the IYA's event celebrating women in finance, in law, and technology. Today we will be discussing specifically law, intellectual property, and technology, the overlap of these three fields, specifically in the context of blockchain technology, smart contracts, adverts, intermediary liabilities, and the famed or the infamous NFTs. In this context, we'll be discussing judgments of the Delhi High Court, we'll be discussing international guidelines, we'll be discussing prevailing trends, as well as the application of technology around the legal system, how to make the legal system more efficient around this technology, and how is it that this technology, if at all, can be regulated, or if there's a desire on the part of those contributing to that direction. Today, we have with us two guests. We have Ms. Meghna Bal, who's a fellow at SCA Center. I might have gotten that wrong. Nonetheless, Meghna will correct me if so, which is a technology policy-focused think tank. She's a lawyer with experience in media and emerging technology. Previously, she's worked on legal and policy strategy at the Walt Disney Company. Before Disney, Meghna worked at Consensus, which was at that point the world's largest blockchain technology company. Welcome, Meghna.
Thanks.
We have with us Ms. Manmeet Kaur Sareen, who's a practicing advocate at Delhi. She attended the University of Cambridge to pursue her LLM with a specialization in intellectual property law and more specifically in trademark and copyright. Prior to that, she completed her LLB from the Faculty of Law, Delhi University. After completing a BA, Honours in Economics from Lady Shri Ram College for Women, University of Delhi. Welcome, Manmeet.
Thank you.
So I'll begin with a broad pitch, and this is a proposition that I discuss with all guests we get on this particular specific discussion regarding tech, IPR, and commerce. The age-old adage goes, the law follows the merchant, right? That wherever, back in the medieval times and thereafter, wherever we had merchants, wherever there were businessmen and entrepreneurs who were specifically dealing in contracts, the law tend to mold itself around those sound commercial practices. Now, as we've progressed since the last 600, 700 odd years, as technology has been developing, technology has been a component that should be considered in this intersection of law and commerce. That is a third step where not only is it that the law may follow the merchant, but the merchant itself will follow the technology. Because as we see, not just today, but ever since the advent of specialized products that went into building better ships that led to the exploration of the world, thereafter the Industrial Revolution, ultimately the sound money has followed the developing technology, which at some point or the other has led to better returns. And the advent of new technology is only possible where there's significant amount of investment flowing in that direction as well. And that is also the broader theme that we would be discussing today. So we'll begin with you, Meghna, on this. Right? In a sense, when we talk about the merchant following that technology, to what extent do you think the law requires a significant amount of catching up to something like that? Do you think that India specifically is on a path that can lead to some sort of sustainability in terms of accepting those technologies, adopting them and utilizing them for better commercial environment?
So this whole notion of, the law falling behind technology has created a kind of conundrum in policy and even legislative decision making, that now decision makers try to preempt the ill effects or the risks, the policy risks or concerns of an emerging technology. And I think that the crypto space exemplifies that, with the recent budget announcement where they brought out a tax scheme that essentially disincentivizes more what in the government's mind are more vulnerable groups, which is your lower income demographics, from investing in crypto by putting a really high tax rate and also putting a transaction tax of 1% on every transaction, whether it be for consideration or even a crypto to crypto exchange. So my whole I understand. I mean, of course, law will always be behind technology, and again, I guess crypto exemplifies that. Because the number of legal touch points that it has, none of the laws really, and especially ones that are concerns for the government, none of them really encompass this technology, and so we're in a gray area. And the problem is until there is legal clarity. So I will say that from the purpose of law catching up, it should be to serve, the greater good in terms of bringing about greater clarity and confidence for startups and entrepreneurs in this space. So in terms of crypto, I would say give clarity on FEMA, and there are myriad ways to do this, but the regulator also has to have the appetite to come in and regulate this space. Um, and I think that we should kind of do away with this whole, I don't know, the notion of the law falling behind, because of course it will fall behind. Technology moves at a much faster pace than the machinations of the state. But at the same time, it shouldn't be. The only danger to this notion is that invariably there's some attempt to preempt policy risks, and in that effort, innovation is jeopardized. And a really good example of this, actually, I think, is the cab aggregator space, where you know um, a couple of incidents occurred in an Uber and in Ubers and Olas, and you had multiple states come out with these really um, um, heavy regulations, especially in Bombay, especially where there were like entrenched legacy service providers. And now it's in those states, especially, it's nearly important. And it was banned in Karnataka. It's like nearly impossible to get an Uber. And here's something that consumers were benefiting from. But because there was this powerful taxi lobby that said that, why they're not regulated, same service, same rules, and look at all the risks they pose. And because technology is new, media pays a lot of attention to it. And because media pays a lot of attention to it, it's on, it's generally uh, riding pretty high in terms of a political priority, because it calls a lot of attention to itself. And then you have this reactionary decision making, which is what happened in cab aggregation, somewhat to some extent in OTTs as well, with the content regulation. And now we're seeing a similar vein, although I would say actually for crypto, some sense has prevailed and they are taking their time with it. But typically it leads to reactionary decision making, which is not good for the industry and it's not good for the consumer either.
I think it's a very interesting point. I will get to the point regarding how regulators might not have, let's say, the stomach to get into this, but also the counterpoint that while I absolutely agree with that, but the counterpoint that to what extent is the crypto industry, or I would say an ideologically pure uh, crypto industry, wanting regulation in that space? We'll definitely
No,
come to that. Uh,
sorry.
yeah, we can get some initial remarks on that, but we'll come back as well. Would you like to add maybe a short sentence on that, or should we
Yeah,
leave
I
it?
mean, I think that if you if you most of the crypto industry, or the crypto industry, does want regulation. I'd say that, it's really just fringe elements that don't, because anyone who's running a business knows that if you have regulation, you have certainty, and that's what you need, rather than the ED filing notices or issuing summons and telling you to come and, asking you, where do you get your Bitcoin from, where do you get this from, where do you get that from, etc. So I think most companies prefer regulations. I think it's a big misnomer that, tech companies live for regulatory arbitrage, and, they want to skirt the law. Of course, like to some extent, there is an incentive to have less regulation, because regulation means, less flexibility in some senses, in terms of how you can operate, greater compliance costs. So it makes it harder. It creates, barriers to entry for smaller players. So there are all these things. But if you have incumbents, then for them there's an interest in having regulation, because one, again, less competition from smaller players, and two, regulatory certainty. And I would say that not only I would say that, I mean, the point of regulatory certainty is a larger concern in India, because really no very few sectors have had it. And the most prominent regulatory force in India, which is the TRAI, I think is a
They've
testament
obviously
to.
been, they've been, yes, they've been asking for that regulation. That's right.
Oh, no, I mean, they are the most. I mean, if there's like a regulatory worst practice, I would say that the TRAI exemplifies that. In broadcasting, it's brought out not less than 70 regulations in 17 years, and it still hasn't been able to achieve any of its objectives, whether the original ones that were set out in 2004, or even the ones that were kind of revised and set out in 2016. Every one of its regulations have been challenged, because the regulator doesn't understand the ground realities of the sector, and it doesn't understand consumer behavior. It operates on, you know um, I would say, isolated sources of information, and therefore it's unable to look at the sector as a whole. And that's just one example, but typically that's how decision making happens in India, and it's really a frustrating thing to observe because it
Fair enough.
only hurts industry and it only hurts consumers. Yeah.
We'll obviously bring forth this discussion as well, but I now like to get in Manmeet. Uh, so, Manmeet, your initial views about how, perhaps specifically in the context of IPR or even otherwise, that the law is catching up. Is it that, okay, perhaps the legislature might have been a bit slow, but the judiciary has been more benevolent in this regard, especially when it comes to protecting intellectual property rights, and therefore giving a more commercial friendly environment in that sense?
I do agree that to an extent, the judiciary may be a faster a body which is probably little at a space ahead than probably the legislature, because what essentially judiciary is doing is trying to or the whole legal fraternity, what they're trying to do is essentially bring technology within the realm of the existing law, right? So when you interpret the existing law in a sense that can even work in the virtual world or in the internet world, then you are reducing the work for the legislature. I also think like that. So you are interpreting it in that way. So I think the Delhi High Court in Ramdev versus Facebook did observe that technology is galloping. So that means that we do recognize to the extent the fact that what even Meghna said, that they are moving at a very fast pace and there's a preemption requirement. But I think the law is trying to keep pace, as it was also observed there. And the example for that would be, for example, injunctions as a concept. So that has been, I think, changing avatars a lot. Now, started from a normal injunction in an in-person remedy, injuncting a person who is copying your IP, then they are injuncted. So that's an in-person. But when you get to, like, for example, a John Doe injunction, so that was one, how you can extend those rights to in rem, right? And then when the internet came in, we required that we need to have something that transgresses borders, because what essentially you can see on Facebook, on Twitter, etc., etc., you are it does not stay within India or within US or within, unless it's specifically made for that. But like, for example, a Facebook, you can see content from all over the world. Like, most of the content what's happening in Ukraine, I'm actually following on Facebook. So, like, the real probably stories come out, and I think that's what it's transgressing borders completely. So with that came the geo blocking injunction or the global injunction. And then when we saw the problem with implementation, right? Like, for example, when you have websites which are mirror websites, they are redirecting websites, they are masked websites. So people are trying to upload infringing content based, trying to, sort of, which in Singapore was held as circumventive measures, or uh, that the players adopt on the internet, which is, in a way, though intention is not required, but in a way they are trying to misuse those methods and do that. So how does law keep pace with that? So then we came up with a concept called dynamic injunctions, and which there, like in Singapore, that was the first judgment I saw. I think that is the first judgment. And then there was in EU, there were notions on dynamic injunction initially. So where they said that, okay, let the ISP decide, or let the intermediary decide on if it's an identical content, then let it be taken down, without the plaintiff being required to come back again and again and again to get the specific URL blocked or something like that. So, and we have also in UTV, and then now we're issuing John Doe in even like the Dabur case. So we are, so based on all these examples, we are trying to keep pace. Of course, technology will move much faster. For example, if I get an injunction today, and if the URL it comes up, by the time I'm actually getting the interim order, the next URL will come up. So how do you, that gap is still to be bridged. How do you do that? So it is trying to keep pace, no doubt, but the pace is very different. We may, if there's the hare and the tortoise, I think this is now, we are the hare and probably that's the horse. So I think, we're now in a very different situation, but we are still keeping pace. Therefore, I call ourselves the hare. So we are trying to keep pace, but it's galloping. The technology is galloping for sure.
Yeah, that's true. And that's the nature of it, that it'll
Exactly.
always be a step ahead. But I think it's a very valid point that you make, that ultimately, and that's the note that we began on, right? On some level, the judiciary, in that sense, has been keeping pace, right? That's interpreting the law as it is today to incorporate these technologies, right? Which were not perhaps thought of at that time, or they were not even in existence when some of the laws that we have today came into existence. But at the same time, not just the legislature, but even on the part of the executive, in terms of regulation, as Meghna was pointing out, there is still some. Well, they can pick more pace. That's definitely there, right? Whether in the context of IPR or otherwise, right? Whether we talk about the e-commerce space, right? We'll get back to the e-commerce space, and I want to specifically talk about that. But before that, and we've got a lot of requests in this, and I understand everyone's heard of the phrase, but not a lot of people understand it well. For them, it's just a fancy piece of new, if I use the correct word, fad. But I want to get Meghna in on this regarding NFTs. Right now, Meghna, I'd like you to give a very brief introduction of the concept of NFTs, because a lot of people have sought for that. I'm not requiring you to explain the entire concept, but we're talking about NFTs in the context of copyrights. I'll frame my entire question, and then you can bring in, to whatever extent uh, you'd require some explanation around the process. Now, my understanding has been that a good chunk of the work that's been created as NFTs, whether or not we were to call them artistic works, are derivative works. Right? Whether they're a question of them coming from other popular mainstream popular culture artworks that already exist, whether it's in the form of mimetics, memes that are already powerful and very well recognized across the world, whether there is a reproduction of particular film. Obviously, I'd like you to talk about Tarantino's Pulp Fiction and the launch of NFTs around that, and the legal issues around that. But specifically, what is the best that we can seek in terms of one, enforcing those copyrights? Like, there are two parts to it. One is that there is someone who allegedly violates a particular copyright in creating a derivative work that is an NFT. Right? And the second is that the NFT, in the case that it is an original work, to what extent would that be copyrightable or enforceable? Because ultimately, I can always take a screenshot, right? I mean, that's the larger meme around it. And also, from a practical standpoint, What prevents me from just taking a screenshot without sort of getting into the code of the NFT itself to say, okay, fine, I've got a screenshot. I can save it on my desktop. I can have a look at it. How does that matter?
Right. So, an NFT is a digital asset written in computer code and very, very simply recorded on a decentralized or blockchain ledger. And it's typically used to prove ownership and authenticity of an asset, which can be either physical or digital. So, unlike other cryptocurrencies like Bitcoin or Ethereum, which are fungible, which means that they're interchangeable, NFTs are unique. Um, so essentially, the so most NFTs are built on the Ethereum network. So there's a standard um, for NFTs called the ER721. There's also the ERC 1155. I'm not going to bore you with the details of these, but these are the ERC 721. These are the broad standards that are used for NFTs. ARC 1155 is used for both fungible and non fungible. So, in terms of the issues regarding copyright, there are multiple. Um, right now, Miramax, as you said about Quentin Tarantino's Pulp Fiction NFTs, Miramax is suing Tarantino because they own the rights to Pulp Fiction and anything derived from it. Um, of course, the copyright law is a little um, I mean, copyright law in the US is a bit different from India, but broad principles are the same. Um, I will say that a lot of the issues will be resolved in court. So I think we'll have to wait for this decision to come out to see to what extent both the NFT operates as a derivative work of its in and of itself, and or a new work or a new class of work in and of itself. Does who owns the underlying code? Who owns the metadata to that code, or the hashed version of the metadata, which is just the crypt. Essentially, what a hashing algorithm does is it takes some amount of information and you put it through. It's a function, so you put it through the function and you get a string of numbers and letters. And if you change um, any component of the input, you get a completely different output. And that, in essence, is a big part of how crypto works. So yeah, it raises a lot of issues. And I think that fortunately or unfortunately, courts are going to resolve a majority of them. So yeah, we'll have to wait and see. There are many ways that it can be argued. For instance, you could make the argument that uh, for instance, like a graphic designer can create a unique digital image, and then an NFT project is then recorded on the blockchain, which stores data, and then that image is unique. But in terms of, um, let's say, the Mona Lisa being turned into an NFT, I think real clarity will only come through court cases on this.
Yeah.
I would say that
Thank you.
Yeah, I would say that
Good.
till such time there is clarity, people should refrain from, going the Tarantino route and just making NFTs of, let's say, Amitabh Bachchan or different celebrities and selling them individually, because you will probably get sued, or at least get a notice from the law firm. But yeah, resolution I think will only come when um, it's decided in court. I don't see I don't see legislation moving very quickly on this, not in India at least.
That's true.
Um, yeah.
Well, that's absolutely there. This gets me to the broader point that, okay, on some instance, let's say I even have an original NFT, which is original art, which is not The Godfather or Pulp Fiction or whatever, right? I create art, I digitally paint a picture, I make an NFT. I think even if we have a copyright in that, whether through the code or through the art. The broader problem will always remain enforceability. On some level, how is it that you will stop? You can own the metadata, you can own the code, you can say on this particular chain, this particular image of the Mona Lisa in the form of the NFT is owned by me, but still, what stops someone from merely taking that screenshot of that particular modified version, etc.? I think the point that uh, is highlighted in all of this is, again, the not so age old maxim, perhaps sort of the last half a century or so, that the new law is code or code is law. On some level, we're moving towards something like that. And that also might get us to the old point that, okay, fine, there might be fringe elements that do not want, only fringe elements might want, not want regulation. But on some level, the whole premise, even pre blockchain, pre smart contracts, the premise of Nakamoto's paper had been peer to peer, right? A peer to peer cash system, something that would not be under the control or could be beyond the control of a government. Nonetheless, not that we're pitching that code is supposed to replace law, but on some level, we're slowly moving in a direction where at some point uh, we might go to what are otherwise called sovereign individuals. But on that note, on the fact that we have limitations to how the law works, I want to get Manmeet in on a very, very interesting case that happened very recently. Now, this is the case where the plaintiffs were Tata Sons Private Limited. Right? This is one of the largest business houses, not just in India, but in the world, and who have, over the years, for the last 30 odd years, been getting injunctions against multiple individuals, companies, etc., who've been utilizing the Tata name online and offline, right? But a very, very special case, an interesting case, perhaps one of the first, at least in India, to have the overlap of cryptocurrencies and trademark, where Tata Sons sued Hakuna Matata Tata Founders, a company that was operating Tata Coin. Right? This is a Tata dollar signal coin, right? And this is a cryptocurrency. It had the name, and Tata sued for injunction specifically in the context of its trademark, its trade name being violated. Then in our jurisprudence books are filled, trademark jurisprudence is filled with Tata getting such orders right from the 90s, right? Ever since we got the internet, we've been getting, Tata has been protected because also it's a very well recognized name, right? When the moment you use the name Tata means, okay, fine, this comes from a particular origin source. But Manmeet, we'd like to get you in on what were the facts here? Why is it that the court decided not to grant an injunction here? And what could possibly have been done otherwise? Could it have been the case that, okay, fine, in some other respects an injunction could have been granted, or perhaps later on if we have something similar, perhaps it's about the means of enforceability, perhaps it's about the fact that, because the court talked about territorial jurisdiction, and also the fact that specifically they were not targeting. So I'd like you to get in a brief story of what the case was, which is very interesting, what the court held and what are your views about it.
I think you have basically explained the
No,
what
I
was
just
being
introduced this is
yeah,
all.
yeah, just like in the sense that they were using the currency, but they were not purposefully having a target audience. Here was what the court observed, that once you are, if you're based in the UK, US, for example, then you do not have an Indian presence essentially. But that's what even when we were talking about the last part where we said that it transgresses borders, which was essentially the Whirlpool decision in NR Dongre, etc. That it's transgressing borders, right? So you cannot. But then there was a Prius decision which sort of diluted it a bit. So those what essentially would be an Indian presence in a virtual world. What would be that when you would say India is targeted, right? So um, Tata, of course, is a into my mind, it's a well-known brand. I think I can check it up also. I think it'll be a well-known brand. But uh, even in terms of the legal, legal aspects. So now, when you use a Tata coin, for example, somebody sitting in India wants to buy Tata coin, right? So if they see the term Tata, they would associate with something. But so would you say that it's not available? If they have advertisement, would you say that it's not available? So these are considerations that I think are going either this way or that in different jurisdictions and different courts. But when we say that implementation of an injunction is a problem when the person itself, the defendant himself is located outside. That's where the global injunction or a geo blocking would come in. So of course I do get the understanding that a person needs to be confused at the threshold, and they will be confused only if they know about it. And once they know about it, generally in a non-virtual or in the brick and mortar world, you would know only when they are there. But now you know about them even if they are not there physically, right? So I do think that once it is available for you on an advertisement or to make purchases, or if it is targeted, then it's technically targeted. There is a reputation that is concerned, that you have to build on, which all legislations, it's a reputation. For example, if you're a well-known mark, you're protected in all classes. There is no one class that you're protected. So the financial sector itself will come in, right? That's as a class. So technically there has to be protection. But how do you implement it outside against a defendant who's sitting outside? Now that is an issue that we are facing anyway. It's not just related to crypto. We are facing that anyway. In a global injunction issue, it can be done once, there is, for example, there is defamation. Now the problem that we face there is that defamation law in different countries is different. But let's say it is a defamation everywhere. It is, for example, there are speech rights which override a defamation in one country, but it is not in the other. How do you implement it then? So the issue of it being implemented outside is always there, and that sort of gap is there. It may be crypto, it may not be. Now, where I think things can change, or probably even coming back to the point of development of law, what are we facing problem with? We are facing problem with implementing the hard written law. Okay, like for example, X doing act of XYZ is infringement in India. Okay, but when we come to something like, going back to like a Satyam Infoway, when they said domain names can be infringement, right? Now, taking that concept, there is a UDRP, there is an ICANN, right? They base it on soft laws. So soft laws are implemented like that. So a UDRP will work its place, or an ICANN will the job will be done when you have like an arbitration like WIPO, like Tata goes to WIPO, and they say, okay, XYZ domain name is against us, or any, like, for example, even Hakuna Matata, you can file a case and go that, okay, Hakuna Matata is using Tata, right? So that is implementable even through an ICANN or a UDRP, right? Which enforces the UDRP. So we can think about something like this, where crypto is transgressing boundaries again, and there is a problem of implementation. And global injunction, though I think there can be a mechanism of implementing global injunctions, but there also can be mechanisms where, blockchain and Bitcoin and everything is developing on the fact that they won't be regulated. So why don't they become soft law, try to create a mechanism like domain names did when they came in, right? The concept of domain names itself came in. So when that came in, why can there not be something like this? I am not sort of suggesting it should be. What I'm suggesting is, why can we go down that route? Can we again build something like that from scratch? So if we do not want to be, if that is that's the foundation. If implementation is the issue, if we develop a soft law mechanism and build it on that, and then say, okay, you can do an arbitration and then you can resolve it, and then that will be implemented. So once that assurance is given, then probably even a crypto name can be done with that. So that's probably one thought that I had. Of course, global injunctions, we can come up with a mechanism to make sure that it's implementable. That may always be a hard law written rule that, okay, this is defamation here, this is not defamation here. But until then, probably this can be a solution. I mean, that's just some food for thought, but we can think about it.
That's a fair point. And on that, I want to build up my next question to Meghna. ultimately, when we talk about, again, Meghna will disagree and should say very correctly so that most big industry players want regulation. They want proper, good kind of regulation, the kind that furthers the cause of the industry and the consumer in the crypto space. But building from what Manmeet said, Meghna, I want to bring in a little something else as well. How is it that something from the technological sphere, specifically on the context of smart contracts, can look at changing the legal compliance, the way we look at the law, the way we operate the law, the way we manage the law, right? I'm not getting independency. I'm not looking at the volume of drafting and agreements, contracts, etc. But to what extent, again, it'll take time for companies to adopt. It'll take time for lawyers to say, no, this is something that we can do, this is something that we can execute. uh, because at least those folks who draft contracts will see a good pinch in a hole in their pocket the moment they start propagating something like a smart contract, which automatically completes the transaction upon certain thresholds being met, right? For our audience, to put it very simply, right? A smart contract does exactly that. It's a contract. It has certain value tokens in it. The moment certain thresholds are met, in the nature of, again, you don't even have to have thresholds being met, right? It's up to your discretion to whatever standards you want to set in terms of Section 32 of the Indian Contract Act. Right? If this happens, if this person gives me their property, the particular money goes in. Till that point, it's in the smart contract in the form of an escrow. Now, this is just one element and one kind of application of it. To what extent do you think the legal industry, or the law as a professional practice, whether looking at the drafting side or otherwise, um, could stand to gain from it? To what extent is it practical? At what point is the company or the industry or the firm side of things going to be willing to accept that? Sure, at some point they would require a nod or an approval from the courts. Okay, fine, this is a valid contract, even if it's signed on some black white QR code, or a particular line of code. Do you think something like that is possible some years down the line, perhaps decades? But do you think, especially in a country like India, right? I could expect it in places which are absolutely driven by sort of technology first, and we try to put everything online, etc. Sure, parts of India are sort of also moving in that direction. But to what extent do you see that as something that's practically possible? Do you think it's feasible? Do you think it's going to be commercially sound? Obviously, the initial stages when you set up the infrastructure of something like that, it's going to be costly. But in the longer run, uh, if it's commercially sound, it's going to be practical. Do you think firms will start adopting it?
Yeah, so I mean, essentially, a smart contract is the coding of some kind of business logic, and then, there are contingencies that prompt that operation to happen. In terms of a contract in itself, it's great for, um, enforcement of a contract, a very simple contract. Let's say, like, you've bought property from me, we put the money in a smart contract, and or like you put the money in a smart contract, and as soon as I sign the sale deed, whatever, it like goes in, or it collects that information, and then the money is transferred. There's no like danger. Yeah, I think that it's useful. I don't know in terms of adoption how quick that'll be. I think also it has to be settled as to whether the use of crypto is consideration for a contract, which is what it'll be, is valid consideration. I think you have to, that is the primary hurdle, that you have to overcome, and then you can consider whether industry will adopt it or not adopt it. I don't see it. Yeah, maybe like if decentralized autonomous organizations become a thing, you might need a lot of lawyers involved. But again, I don't see them using it so much as them being relied on to ensure that all the paperwork for registering, all the compliance requirements for such constructs are met. Like Wyoming has brought out a law that allows you to register your decentralized autonomous organization as an, I think, an LLC, And essentially, if it's completely autonomous, if it's completely smart contract based, there's no, or you say there's no human touch point, they only allow you to register it if it's the smart contract is editable. So I don't think that we're looking at, and even in terms of decentralized finance, there is, to my mind, and I studied this pretty extensively, there is no truly decentralized construct that's out there, because you have some kind of entity, some kind of person who is looking to profit from it. And even if you have something like Bitcoin, where you don't know who the issuer is, all Bitcoin that has been issued is now owned, and those holdings are pretty concentrated. It's well documented. So I don't see, like, the only problem I see in terms of like people adopting it is, I don't even know. I don't think that beyond, like, at least immediately beyond it being a quick way to execute a contract, or a simple contract, it being efficient from that perspective. But I don't see it like widely being adopted unless, cons- customers start demanding it. That, look, I don't, in India, it's not like, it's difficult to enforce contracts in this country. I'd like to opt for this option if I'm buying property. But again, like, there's a lot of legal hurdles that you have to overcome for that to become a realizable construct. And I don't see that happening very quickly. I mean, if you look at just the simple digitization of land records in this country, even though they say that 95% of land records in India are digitized, it doesn't really mean anything, because they may have, like, for instance, and I've done some work on this as well. For instance, in one state, they digitized all the land records in 2015 or 2016, and then they just went back to using paper because no one had been trained on the software. And they were used to working in a certain way. And I think things will change incrementally and slowly, but there's a lot of hurdles to adoption of tech, and particularly complicated tech. I'm not saying it won't happen, or it's like beyond the realm of plausibility, but there's a big there's a wide chasm between um you know um something that seems like, between a gimmick and, like, let's say, like, something that is practical or quotidian construct. And I think that from something to evolve from, a novelty to becoming an entrenched part of any business operation, it takes a long time, particularly in tech in India. I'm not saying it can't happen. I'm just saying there's a lot of legal hurdles, administrative hurdles for it to fructify. And those have taken a long time, even when really, really uncomplicated digital processes. So when amp up the complexity of the technology and its intersect with that complexity, its intersection with law and other and legal constructs in general increases as well, then you're looking at a much slower rate of adoption, essentially.
I think that for me, the key takeaway from something like that has to be that to what extent is it that those who are in tech start creating their technology by thinking of how the law is. One, that's never going to be the case. The second is to what extent is it that lawyers themselves are willing to say, okay, fine, let's put the technology first and let's start thinking from that ambit. I see to some extent the latter happening more often than the former. And on that end, on that particular note, Manmeet, I want to get you in on our last question for the night, which is the point that we began on. That's to what extent is it when these things overlap, when there's a technology that's created and the law starts building itself around it. I want to talk about intermediary liability. I want to talk about specifically the question of AdWords, right? AdWords for our viewers is Google AdWords, right? Like I did with Hakuna Matata. I'm not going to give too much information, then Manmeet's going to say, you explained it all. So I will keep that entire space open to Manmeet, right? To talk about Google AdWords, the recent judgment by the Delhi High Court, how the jurisprudence around that is developing across the world over the years since the meta tagging days, domain names, and thereafter now with AdWords specifically. What the particular judgment says, what the broader issue is, and obviously this is something that remains in the judicial domain even till date. But wherever we've reached till now, Manmeet, if you could give us an overview and your views on that as to how perhaps we should be proceeding.
Yes. So, okay. So then Google Ads, essentially the issue is that how can I break it down? Yeah. So when you are using a mark, right? When you're, let's say, selling something, then you're using a mark, and the consumer sees that mark, knows the origin of the good, and therefore buys it. They can indicate quality. They can indicate a lot of things. For example, if you buy, if there's a phone, if there's a smartphone, and the smartphone has an Apple logo, half button, then you know it's Apple, right? So you know it's Apple Inc., right? So you see it, and that's how it works. Now in Google Ad Space, what essentially happens is that Google allows a place for ads, which is the search results. They have two kinds of search results. One are sponsored and one is organic, right? Sponsored are those for which Google takes money, right? So it's for a monetary consideration that the ad is placed specifically. For example, I very breaking it down really into very layman terms, I pay for a space, and Google provides me with that space. If it's on the first page, I pay an amount. If I want the first result, I pay another amount. So I pay. So that's how it works. It is not only on payment; it depends on a lot of other things. For example, let's say now Google essentially works on what we have to remember. Google works on it being a search engine. Like, we are now to the extent that some people say that Google is now a generic term. Like, you use it anonymous to search. So for example, I will say that, okay, I have a question in mind. I won't say look it up, I say Google it. So it's essentially, anonymous to search. So Google works on that, right? That's its USP, that it's a good search engine. So for example, if I have an ad, I want Google to place it in a particular place. Now, if I type something, let's say I want sports shoes, okay, I say, okay, I go to the Google search bar and I write sports shoes. Now Nike may show up, Reebok may show up. So when you click that, if it goes to the best place, if so Nike may have a huge website, but the landing page would be the sports shoes page. So if it's a good landing page, then also it will show up on higher on search results, right? So that's essentially how Google will, with its algorithms, will work. So if you have a good ranking, if you've paid higher, if the quality of the website is good, so you will get a better position on its search results. Nobody will go to the 10th page to see. Everybody wants to be on the first one. Now, when you have that, the main point is that I am entering sports shoes in the search bar, right? When I'm entering that, how is it that Nike comes, for example, this is just an example, how is it that Nike will, let's say, come first and Reebok will come second? But if I type Reebok, then Reebok sports shoes, Reebok will come first, Nike will come, let's say, second. This is hypothetical. So that's where Google Ads as a platform, the platform for the advertiser, works, right? So what they do is they essentially connect certain search terms that they want. So let's say sports shoes, I want my sports shoe to come up, right? So when I'm making my ad, I will choose a search term that that directly links the user to my brand, right? So then let's say if a person enters sports shoes, it pops up, right? Now, what does Google do in this? What is the role that Google plays? There is one method that I only say, okay, I want sports shoes, sportswear, I type all of these as like just what comes to my mind that may be search terms for my product, and I place them for my product, right? What Google does is sometimes it gives you a list also, right? Now that list essentially is a tool for you to apply certain search terms for your product. And how does that list come? It's like a search engine within a search engine. So it's the search engine for the advertiser. Okay. So how do you know? You just type, okay, this is my product, this is what I want, so the search terms will come up. Right? Now these are the search words that have already been added. Somebody has searched for them. What is the volume? What is the competition? It'll give you all statistics. So that's basically how Google Ads will work. It's a it's a very layman concept. Even I'm understanding it very recently, but yes. So now the problem happens is, let's say I say, okay, when I put my sportswear up, I am Manmeet Sportswear is my brand. And but what I do is I say, okay, and this is at the back end, right? The consumer cannot see it, what search words I am applying with respect to my product. Correct? So it is a back end, right? So it's not in the forefront, it's back ended, right? So when I apply that, I can say, okay, if Nike sportswear, I apply Nike sportswear to my brand, okay, let my brand also come up and I pay higher. So Google's algorithms will determine. I'm not saying it will come above Nike on the search results when Nike sportswear is entered, but it is a possibility, right? Depending on the algorithm. Here's where the problem happens. Now the problem happens because Nike, if you may say, okay, if I'm entering Nike, why does Manmeet's brand show? It shouldn't. Nike has a reputation. Nike has a brand loyalty. Nike has built its image. Why should Manmeet piggyback ride that reputation? Correct? But the problem is when I'm entering Nike, it's not Manmeet entering Nike. It is the user entering Nike. So essentially, I'm not using the mark with respect to my product. On my ad, Nike is mentioned nowhere. It is not mentioned on my Google ad title. It is not mentioned on my ad description. It is not mentioned in my URL. So essentially, what the argument is taken is that the consumer doesn't even see the use of the trademark. So when they don't see the use of the trademark, how can they be confused? And if they cannot be confused, how can it be infringement? That's where the issue comes in. So therefore, like a meta tag, which is the source code of a page, this is a back end trigger. Triggered for what? Trigger for the consumer to go and click on Manmeet's shoes by typing Nike. So, but who's typing Nike? The consumer, not Manmeet. So, is Manmeet infringing Nike? Is the question.
If you were to permit me to come in, not just with a thought experiment, but something which is a practical reality of the online commerce space here. What if there are only two players in the market? Right? There's Manmeet Sportswear and there's Meghna Sportswear. And these are the only two players, they're competitors. I specifically type in Manmeet Sportswears, and the first hit that I get is Meghna Sportswear. What then? There are some instances that we've seen. Again, we're not even getting into dilution, we're not getting into riding, but something as specific as that. I'm not saying that it's not happening in the background, but something as specific as that, where there are two big players, or there are only two players or two dominant players in a particular market, and the first hit that you get, even above the where you get the ads or promoted, etc., is the name of the only other competitor, which has a very distinct name. Here we can obviously make an Eminem. I really wanted to bring in this pun for the net, but other than that, where two names are absolutely distinct, that changes. Shouldn't that change the ball game to some extent?
In terms of, see, likelihood of confusion will anyway not apply because the consumer is not essentially being able to see the mark used with the ad. So if Meghna uses my mark, my name, like that's my mark, with her ad as a back-end trigger again, the consumer cannot see it. Right?
But it gets you to her website. If I type, yeah.
So when if the question is if you cannot see it, can you be confused? That's the question. Right?
In a world where we move on clicks.
Yeah, because there is no use by Meghna which is perceptible, essentially. Right? But is she still riding on my reputation? Probably, yeah. She's using it in that sense. Meghna, I'm not saying my reputation is better, but I'm just But I'm just saying that if there is a better reputed mark and the other person is using that loyalty, is she still using it in that context? Yes. And does the trademark law stop it? Yes. There's a concept of dilution. It stops it. So that will be still be infringement on Meghna's part. But the problem with DRS logistics was not Meghna's liability. The problem with DRS logistics is the intermediary liability. Right? So is Google responsible? Every time, it's always the problem with the intermediary lab. So is Google responsible? Google is
Yes.
not using the trademark. Yeah, I mean, the court held that, but because they're taking monetary consideration. But is Google responsible is a question if you want to interpret the law. Even right now, this interpretation is still going on. I think they've already challenged it to the Supreme Court. So the interpretation is that whether there is use, whether there is confusion, because there is a concept of initial interest confusion, which was, I think, I'm not sure of the name. I think but there's a US judgment where it came in where they said, sorry?
Blockbuster.
Yeah, Blockbuster, exactly. Blockbuster example. I'm forgetting the name of the judgment. The Blockbuster example where they said on a highway if you're going, and yeah, and there is first exit to, let's say you get there's an okay. I will explain it in another way. I will explain it with the Sherman Cafe example in Sherman Bentley. Okay,
Yeah.
you're going and you want to go to McDonald's, first exit, but it actually is not McDonald's. It's Sherman's Cafe, but it uses McDonald's in a way that you can go to Sherman's Cafe. But McDonald's is the next exit. Who will go back to the main exit and then go to McDonald's? I'll just buy a burger from Sherman's Cafe.
Exactly.
So, but internet doesn't do that. Internet, you just have to go back, like literally click back, right? So
Easy.
there are a lot of it's very easy. You cannot be confused. The confusion goes away. So how do you apply? So initial interest confusion came because of this virtual ad space itself.
Yes.
But the analogy can be disputed. So let's say a disputing analogy is, let's not take a highway example. Let's take a supermarket, right? If I go to a supermarket and let's say it is Manmeet's product and Meghna's product, let's say both of us sell anything, like for chips, okay? They will be kept on the same aisle, probably next to each other. That increases competition. It does not technically create infringement. So that's another view that is taken.
But whose chips are at the most convenient ergonomical place for the consumer to pick up first is where the supermart owner or the intermediary has a
Correct.
role to play. I'm not saying there's liability.
Correct.
Yeah.
But
they
if
have
it's,
a role to play, right?
if it's kept on the third row next to each other, what do you do? What do you say? Right? So
And if I'm
I'm
paid,
I'm paid. Like I'm paid to run this.
yeah,
And I am giving you the space. And I'm not giving you an exclusive right. So if Nike wants to use Nike, Reebok can use Nike, Manmeet can use Nike, Meghna can use Nike as an as a search term, right? But so there's no exclusive right like a trademark gives. So Google does not give trademark. Google just gives you the ad word. That's one concept. But they are taking money. They are making monetary gains out of it. So that's the now. Are they furthering infringement? Is the question. Are they having an active control and monitoring obligation here?
exactly.
So then, if you bring that concept in, then you can be yes, they are having it, and therefore they should be held liable, which was even held there that they first of all that they are having different policies in EU and here,
That
etc.
changed post 2004.
Yeah. So, but the basic fundamental goes to that. So I'm not saying that there is. I'm still debating this in my head, but I think that there are fair arguments on both sides in the sense that in my view there's no likelihood of confusion. In my view there's dilution and that's it. But does the intermediary be held liable for dilution? If it is doing an active control and monitoring, yes. And if it's not, then no. So that's kind of my take on that.
Meghna, would bring you in for your last comments. Manmeet said something, and I want to quote that specifically. Google does not give trademarks. Right? We go back to the long point. Code is law. How close are we getting to that? Or any other comments that you'd like to end on?
Um, well, an interesting example I think of that is what global crypto exchanges are doing to comply with the travel rule, which is an international obligation set by the Financial Action Task Force, which is a global anti-money laundering and countering terror finance body, which basically says that the initiator and the originator and the beneficiary of a transaction, both the entities facilitating a transaction, the originator and the beneficiary, must transfer the personally identifiable information of the people who are engaged in that transaction to each other. So they must have that information. Now this becomes quite tricky with crypto because different different forms of compliance or different levels of compliance in different countries, depending on whether they're regulating crypto or not. So for instance, in India, we don't have that. Right now there's no direct obligation on crypto exchanges to comply with this, but essentially what they're doing is they've come out with this a bunch of exchanges have come together and come out with this travel rule solution, which is essentially a uses decentralized identifiers to so essentially what you do is it's a solution where you, as in, say I'm an exchange and Manmeet is an exchange and I want to buy some crypto from her. So I'll ping the solution and the solution will give me all of Manmeet's information. And so I'll have it for the transaction. And similarly, Manmeet will have all of my information and we'll have this information. And essentially, and it's also like ensures that our privacy is maintained, but we have this information and we can engage in this transaction. So in terms of a global, yes, I think that for compliance, we're moving towards more automated solutions and away from paperwork. In terms of code actually being law, I think uh, eh, we have a ways to go, at least in India. um, because there's hard friction. And I think we're seeing that, yeah, with the intermediary liability and the way it's kind of playing out in this country. I think now lie on the other, well, I don't know, intermediary liability is an interesting one because it can be misused, to serve political ends where you basically pretend like you're going to squeeze an intermediary with some law, and then to have them cater to your demands. But at the same time, I think that, especially from, let's say, a copyright enforcement perspective, intermediaries new and from an IP perspective in general, intermediaries need to um, become more liable. I think that the threshold of liability does need to increase. And towards that end, we do see some decent and then some imperfect solutions, I guess, like Content ID, where there's like just widespread blocking of videos on YouTube, because, they match some form of um, I mean, there's like some overlap between, um, what has been inputted
Whatever is
into.
violative of the
Yeah,
contravening.
whatever was violated, whatever someone has said is their IP or not. And that has also been misused to like bring down, let's say, news websites or parody or news videos or parody videos. So yeah, the problem, I would say, of code becoming law, or there being um, digital companies being uh, the responsibility of enforcement being devolved to digital companies, is that they will err on the side of um, I mean, they will basically over enforce to protect themselves. So you have I mean, essentially, I guess, yeah, you have a landscape where the consumer is typically worse off as a consequence.
Yeah. With
So
excessive regulation, when is that not the case?
yeah,
But nonetheless, thank
RBI
you so
would
much for.
disagree, but
Sorry.
said the RBI would disagree with the e mandate, which they apparently brought out for. consumers.
The
I
RBI
don't know.
would disagree. Absolutely. That's why we don't have all the
I don't
domain
know if you
names
guys
that
had
we
a
bought
problem with that.
working anymore, or monthly payments
Yeah, I
going through.
don't. Yeah, I don't know
Sorry?
if you guys had a problem with that
Yeah,
when
I
we
did.
managed.
I certainly have had that problem. I
Yeah.
bought a nice domain to serve for a lifetime, and now it doesn't work. And the RBI notification came in a week after I bought that.
Oh shit.
So now it's absolutely shut down. Can't even use
Yeah.
it. Nonetheless, thank you so much, Manmi. Thank you so much, Meghna, for joining us for this very interesting conversation. And for all our viewers, celebrating Shakti will continue for the next week. Tomorrow, we will be talking about specific careers and personal journeys and experiences in the field of STEM. We have two chemical engineers, Mrs. Sakshi Khanna and Priyanka Khemka, who will be talking about their careers on the broad theme of women in STEM. So please do join us tomorrow night as well. Thank you so much, Manmi. Thank you so much, Meghna. And thank you so much, everyone, for joining us. This is a good night from the air by here.
Thank you. Thanks.